Good morning, Your Honor.
Are you in a morning time zone? I'm in an afternoon time zone.
Yes, sir. Afternoon time zone.
Hello, Mr. Trainer. How are you, sir?
I'm doing well, sir. How are you doing?
Hey, I'm doing fine. All right, this is cause number CR 2262, State versus Corey James Butler. I have a note here that says federal custody. I've been on the Bureau of Prisons locator. I don't see him in there. Do y'all have any information for the court?
I do not. I was under the impression that he was still over there being held waiting for transfer, but they might have gone ahead and transferred him. I'm not sure.
Do you know where he was supposed to end up next on his transfer?
I do not. I'm sorry. That's just not my that one wasn't my case on over there, and I wasn't aware that they were transferring him anytime here soon, so I hadn't heard of that yet from them.
Well, and I think all of us that have dealt with the federal system know that the inmates don't always show up on their website, so it's very likely that he could still be in their custody and just not on the public website. So, State, do you have any information or resources we can use to determine if Mr. Butler is still in custody or not?
Judge, I do not know if he's in federal custody. I can relate to the court. He's not in our custody, and hasn't been since April. I am unaware of where his current whereabouts are. We have reached basically an agreement that once he has resolved his federal business and been sentenced federally, we will resolve this case. But we're basically waiting for the federal system to take its actions upon Mr. Butler, and then we will resolve the state action thereafter. So if we could reset it for a status a couple of months out, so we can try to let the federal system work, I think that would be our best cause of action at this time.
But is it fair to say that at this time, neither the state nor the defense knows where Mr. Butler is?
I think that's fair to say, Your Honor.
Last week, I know he was still there in Henderson, so but I can't speak for anything here since then.
In the you're talking about the county or the city of Henderson, or where?
It's the I believe it's the Henderson County is where they got the hold on him.
Located in Athens, Henderson County, or Henderson, Texas? Henderson is in Rusk, and then Henderson County is county seat of Athens.
Yeah, I thought it was the Henderson County jail was where he was at.
It does appear as though he is. It says federal detainer in Henderson County. I don't know if he's still in Henderson County currently or if he's been released. It doesn't say released. So he very well may still be in Henderson County on a federal detainer. It says warrant number federal inmate. Issuing off authority is the Marshal Service.
You can look, sorry, it's not my case, but you can look that up online, Henderson County, the jail, if you just Google Henderson.
That's where I'm looking right now.
So they are showing him in their custody?
It does appear as though he is in custody in Henderson County.
And so he's in federal custody, or he's just being detained for federal custody?
I believe he's in federal custody, Your Honor, and they're just using those facilities there until they figure out where they're putting them.
And so both of you are indicating that he's going to have to be taken from their custody, taken to a Bureau of Prisons and accept some sentence, and they were going to have to bench warrant him back from some federal institution.
That's my understanding, Your Honor.
Mr. Woodwhite, you don't believe that you could move forward on your state charges at all before? I don't want to find out that he's going to be shipped off to Colorado, and then we're going to have to go pick him up when he's just.
Judge,
on
this state's understanding is that Mr. Butler is going to be getting federal time. And once he does in fact do that, the state plans on dismissing this charge. Given that he's going into federal custody, we don't want to just dismiss our charges in case something happens with that.
And currently, Your Honor, what they want from me is a copy of the plea paperwork, which I've been trying to get. Unfortunately, it seems like the plea is actually under seal right now. And so the attorney that's representing him, although I haven't actually talked to him, I've just talked to his assistant. They've told me that, that they're reluctant to hand that over to me because it's under seal. And I asked them, just, send me over some sort of proof. I have not received it yet. And I'm going to be blowing him up again, trying to get something from them.
Okay, and how long has he been going through this federal prosecution? What I'm trying to figure out is how long are we going to wait, and how long do I need to set this out?
Judge, he was booked into Henderson County 5/27 of this year. So 7 months ago, it looks like he's been sitting in Henderson County on a federal hold. I have no information how much longer that process will take. As you said, the feds do what the feds are going to do on such things, and they take their own time frame. I have no information on how long it may still be.
Have you been in contact with the federal prosecutors, Mr. White, to determine that?
I have not. Miss Curry, I believe, spoke with a federal prosecutor. I don't know if it was the specific assigned, but there was an indication he was going to prison, which is why I think we released him from Van Zandt County to go to Henderson County to go into federal custody. Or
Okay.
we released him. He went to Henderson County, and that's where the feds placed their detainer. That's basically the extent of what I know about this.
All right, what I'm going to do is I'm going to set this for a final hearing on February 21st. And either I would expect him to have taken his federal sentence, not taking it. State tells me what they're going to do, not going to do. So we can decide, are we going to request a bench warrant rather than just, I don't want to look up and a year have passed and we don't know where he's at or what he's doing and those things. So I'm going to set it for February 21st and expect some kind of either good idea of what's going to happen and when it's going to happen, or state can dismiss, refile. I don't know. I mean, do something other than letting it ride.
Yes, Your Honor.
All right, Mr. Trainer, we'll see you back on February 21st at 1:30.
All right. Thank you, Your Honor. We'll talk to you soon.
Thank you. Mr. Weiner, are you ready?
Yes, Your Honor, good afternoon. Take court. I believe it's under Mr. Head's name, Judge.
Yeah, that's what I was looking for. All right, this is cause number CR 15475, State versus Corey Demond Prox, motion to revoke. Mr. Weiner, I had a discussion with Miss Karen Wood over the lunch break in preparation for this afternoon's docket. And in my discussion with Miss Wood on the motion to revoke, it came to my attention that I was involved in the prosecution of the underlying offense for which Mr. Prox is on community supervision. So I've taken the steps to recuse myself under the grounds of disqualification and have filed that with my presiding judge. And I had my coordinator send you a copy as soon as that paperwork was prepared. So
I actually received it about 10 minutes ago, Judge. I appreciate it.
okay, so we'll have to wait for my presiding judge to make an assignment in that case, and then we can get the case docketed.
Okay, thank you, Judge. I appreciate your thoughtful consideration in that. Appreciate it. May I be excused?
Yes, but let's go ahead and set Mr. Prox just so that he doesn't fall between the cracks and time get wasted. Today is 13th. Let's set him for Are you available on Thursday, January 5th?
Yes, Your Honor, I'll be available January 5th at 1:30.
Now, if the presiding judge makes an appointment today or tomorrow, we have another criminal docket on Thursday of this week. So I understand that you may have a motion to set bail. So if that's the case and you want to get that heard sooner rather than later, if that appointment's made in that time, you can ask Ms. Abraham to set that. If the assigned judge is going to be available.
Yeah, I appreciate you giving me heads up on that because we definitely would take advantage of that if possible. So I appreciate it, Judge.
Okay. All right, so we'll set Mr. Prox for January 5th.
So it does come available. And that's all I have. Excuse.
Yes, thank you, Mr. Prox.
Thank you. See you.
Mr. Schmidt, are you ready on anyone?
Kendrick, Irvin.
Irvin? Kendrick, Irvin, CR 21-357.
That's correct, Judge. That'll be a plea.
All right, what are the terms of the plea?
Judge, upon a plea of guilt, state's recommending that finding of guilt be deferred. That'll be placed on 3 years community supervision, assessed $1,000 fine, 290 in court costs, 585 reimbursement fees.
Any 1245s or weapon forfeitures, anything like that?
Not that I'm aware of, sir. I believe this is his only business in Gadsden County.
Okay, just one moment. All right, Mr. Irvin, raise your right hand, please. Mr. Irvin, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. Mr. Irvin, just make sure you speak up loudly and clearly for me so that I can hear you and my court reporter can take down everything you have to say. Okay, sir?
Yes, sir.
All right, Mr. Irvin, you are Kendrick Lyron Irvin. Is that correct?
Yes, sir.
And Mr. Irvin, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
And are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
And you feel like you've had enough time to meet with him about your case, talk about your options, get all of the questions answered that you have regarding your case?
Yes, sir.
Mr. Schmidt, do you believe Mr. Irvin to be competent today? And if so, have you explained to him his rights and do you believe he understands them?
I have, yes, on both counts.
All right, Mr. Irvin, you are charged with the third-degree felony offense of evading arrest or detention with a vehicle. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a fine not to exceed $10,000. Now, you've heard the plea agreement that Mr. Schmidt read to the court. Is that correct?
Yes, sir.
And Mr. Irvin, do you understand that if the court approves that agreement today and places you on community supervision, do you understand that if you violate the terms of your community supervision and the state brings you back for a hearing and they prove it to the court could, as a consequence, could revoke your community supervision and could assess your punishment anywhere between that range I just told you, not less than 2, not more than 10, and a fine not to exceed $10,000. Do you understand how that works?
Yes, sir.
And understanding all of that, do you still wish to go forward?
Yes, sir.
All right, Mr. Irvin, how do you plead then to evading arrest or detention with a vehicle?
Plead guilty.
Are you pleading guilty to that crime because you are in fact guilty of that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
All right, anything further from the defense?
No, sir.
All right, and state, can you give me the facts to support the plea?
Yes, Your Honor. The Canton Police Department gets a tip that there's stolen vehicles going down the highway. They set up and confirm the license on the highway. They set up on the side of the highway and confirm the license plate. CPD attempts to pull the vehicle over and it begins to slow roll on the shoulder. It then accelerates away, basically just inside the Kaufman County line. Kaufman County uses spike strips to disable the tires and defendant is taken into custody. I believe there are 2 other passengers as well, but defendant is the driver.
Thank you, Mr. Butler. Any objection, Mr. Schmidt?
No objection.
All right, based on the evidence presented, the court finds that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Irvin on 3 years community supervision, orders him to pay a $1,000 fine, $290 court cost, and $585 reimbursement fees. Mr. Irvin, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. You'll go over with the deputy to be fingerprinted, and then the probation officers will give you more information.
Yes, sir.
And Mr. Schmidt, whenever you're ready, I'm fine.
Oh, okay. Thank you, Judge. I've got Mr. Gurley.
All right, Jeffrey Lance Gurley. Mr. Gurley is set for pretrial in all of his cases on the docket.
That's correct, Judge. We've had an opportunity to review the evidence. We've met several times. State's made an offer Mr. Gurley is going to accept. We'd ask that that be set for a plea on that February 7th docket.
Okay, court will set Mr. Gurley for plea on February 7th at 1:30.
Yeah.
All right, who do you have with you, Mr. Schmidt?
Aaron Alvarez.
All right, this is cause number CR 22-260 through 265, State versus Aaron Alvarez. Go ahead, Mr. Schmidt. I think we're set for pre-trial on all cases.
I believe that's correct, Judge. We've received an offer from state. Mr. Alvarez intends to accept that as if he set for plea on that February 7th docket.
All right, court will find there are no pretrial contested motions and will set this matter for plea on February 7th in all cases. That'll be at 1:30. Who's next?
Cody Ledbetter.
All right, this is cause numbers CR 22-186 and 187, State versus Cody Wayne Ledbetter. Is this a plea today, Mr. Schmidt?
It is not, Judge. Damn. Previously,
Is there an issue?
yeah, we got a jackhammer going out in the hallway. I hear myself thinking. Mr. Ledbetter was transferred to TDC through Collin County. I think at the point that was going on, me and Ms. Heisel were in the midst of negotiations. We have not reached an agreement. However, I anticipate hopefully making some time tomorrow to speak with Ms. Heisel as well as Mr. Ledbetter here in custody to see if we can't get a resolution, which we would like to do. And if we can, I'd ask the court to entertain a potential plea on Thursday, just so that we can get him out, get him back down. I can't guarantee the court that we will have an agreed resolution, but the goal is to do that as quickly as possible.
Do you want me to reset it for Thursday?
At this point, Judge, I don't think so. I think that if you set it for normal docket day, I will meet with both individuals involved. And if we reach an agreement, I'll notify Ms. Taberham and ask to squeeze in Thursday afternoon.
Did we bench warrant Mr. Ledbetter for a plea, or did we bench warrant him so he could talk with defense? And the reason I'm asking that is I wouldn't be inclined to keep Mr. Ledbetter in our custody if there's not going to be an agreement. If it's going to be a trial, I would just send him back down to TDC. And,
Well, and Judge, it's my understanding that Ms. Taberham believed we had an agreement, but I never relayed that, neither did Ms. Heisel. I think it was wishful thinking. It is, it's our goal as well. Mr. Ledbetter is interested in resolving this case as well as is serving a TDC sentence. So I understand the court's position.
well, I can tell you this, Ms. Taberham doesn't operate on wishful thinking. We require a request from either the defense or state before we bench warrant, because we know what kind of burden it puts on the taxpayers and the sheriff's department to accommodate that. So.
And Judge, I can relate to the court that I forwarded, Mr. Schmidt and I had a communication that I forwarded to Ms. Taberham that essentially said that Mr. Schmidt didn't believe that he could confirm whether or not there was an agreement until Mr. Ledbetter got to Van Zandt County, where he had access to him to discuss the plea offer in the case. And so we asked Ms. Taberham to go ahead and bench him back just so we had access to him. If we don't have an agreement in pretty short order, Judge, we would have no objection to him being sent back to TDC. But we got him here so we could talk to him and see if that was a possibility to resolve it. That obviously, if we can resolve it, I think that's in the best interest of everyone. I don't think Mr. Schmidt and I are terribly far apart. But if we're not able to do that, we'll let the court know as soon as we know the answer to that.
But that could cost us 30 days though in custody, right? Is what you're telling me.
Judge, I'll announce to the court that I'll meet with Ms. Heisel tomorrow. We'll either have one or we won't. And if we don't, then, release the bench and we'll put him on a trial docket. I mean, the goal is to resolve it on Thursday. I would like that. Mr. Ledbetter would too. I can't guarantee it, so I'm not gonna
Right.
notify the court.
Yeah, no, I appreciate that. That's why I was asking, do you want me to set it so we would have a deadline for Mr. Ledbetter to work on? I just didn't want to set it in February and then us find out in February that there is no agreement, and then we send him back, and then it takes 60 or 90 days to get him back to TDC. And he's gonna be losing any priority or any classes or whatever he may have gotten into at TDC, he's gonna lose all that the longer he stays here.
Right, I understand. Obviously, I'm hedging. Hoping for one, and if the other happens, I just want to have it set up. But if you want to set it for Thursday, we can. If necessary, we can reset it. I'll be here either way.
Are you already scheduled to be here on Thursday, Mr.
Yes,
Schmidt?
sir. I've got several pleas on Thursday.
Okay, all right, then. Let's set Mr. Ledbetter for Thursday, the 15th for status or just for a docket call, so we'll know. We'll call it docket call. And then if Mr. Ledbetter accepts the plea, then we'll do it that day. If he doesn't, then we'll release the bench and send him down and set it for jury.
Yes, sir. Thank you, Your Honor.
This is CR 21-146, CR 22-297, State versus Ronald Darren Toll. Motion to revoke and docket call, I believe.
That's correct, Judge. I think we're pretty close to reaching a resolution with the state. I've spoken with Mr. Woodwhite a couple times, and I've spoken with Mr. Toll here again today. I think we're right there. If we could set it for one last docket call, hopefully we'll bring a plea to the court on that day.
All right, court finds that this is Mr. Toll's first setting on docket call for the charge of arson. So we'll set both cases for docket call on February 7th at 1:30. Who's next, Mr. Schmidt?
Ryan Collier.
All right, this is cause numbers CR 22-126, CR 22-127. And do you also have a writ on file WR 22-109?
That's correct, Judge.
Okay. Go ahead, Mr. Schmidt.
Judge, to begin with, I'll start with the writ. Mr. Collier was arrested for, I believe, the charge of aggravated kidnapping. That particular offense remains unindicted. He's been in custody well over 90 days. Under 17-151, we would ask that the judge or the court grant Mr. Collier PR bond under the provisions of 17-151. I also have motions for reductions on the 2 indicted cases, which we would take testimony on.
All right, Mr. Collier, if you'll raise your right hand. Place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. Make sure you speak up loudly and clearly. Go ahead, Mr. Schmidt.
Thank you, Judge. State name for the record. Brian Keith Collier. And you are currently in the Van Zandt County Jail on 3 separate charges, correct? Yes, sir. And that you're indicted for aggravated assault with deadly weapon, correct? Murder, correct? Yes, sir. And you were arrested on aggravated kidnapping, is that correct? Yes. And what are your total bonds set at this point?
It's my understanding that currently it's 900,000.
900,000 total. So on the murder charge, your bond set at 750,000.
I was under the impression it was 500,000, but it may be 750.
I believe it is, but either way, the total is in my motion. And at this point in time, you've been in custody since what date?
February 2nd.
February 2nd, and you have not received an indictment on the aggravated kidnapping charge, is that correct?
That's correct.
As far as the indicted cases, on CR 22-126, your bond is set at 500,000, correct?
Yes, sir.
And on CR 22-127, your bond set at 150,000. Does that sound correct to you?
Yes, sir.
All right, and at this point, you've been in custody nearly a year, awaiting trial on these causes, obviously. You cannot make bond on, as said, correct?
As said, it's gonna be too loud for me to make.
All right, and you
I'm
have.
sorry, Mr. Schmidt, I couldn't hear what he's saying.
Yes, bigger.
As it stands, it's currently too much for me to post.
And did you have a code?
I'm sorry, Mr. Schmidt. It's not him on that time. That time it was the technology getting it garbled up. I wasn't able to hear that. Just have him repeat his last sentence again.
Yes, sir. So Mr. Collier, as said, you cannot make bond, is that right?
That's correct.
And you had do you have a co-defendant in these offenses?
Yes,
And what's her name?
Shane Adobe.
And has she made bond on these cases?
Yes, she has.
All right.
She also sought a bail reduction and received one.
I see. And so ultimately, if the court were to reduce your bonds on these cases, what amount do you believe you could make?
I only have the, what the bondsman is telling my loved ones. And currently, as it stands, they want $63,000 if the bond doesn't get reduced. He says that if I can get it to 600,000, possibly 500,000, he would accept 20,000, and then it would be up to my family members to provide those gifts.
Whether or not they can come up with that.
Yes.
Now, as far as you're concerned, do you have any real property or any property of value that you can sell in order to make the bonds as set?
No, not currently. After my arrest, our house was just ransacked by individuals, and I have absolutely no belongings of my own.
Okay, you don't own a house?
No, sir.
And do you own any stocks or bonds or anything like that you can liquidate to pay for your bond?
Not at all.
And if you were able to make bond, do you have a way to get back and forth to court?
Yes, I have a vehicle provided by my son.
All right, and where is your residence if you were to be released?
It would be on Southview Drive in Dallas at a sober living men's home, a Christian sober living men's home.
Okay, and have you been in contact with that home?
Yes,
And have they given you an indication that they would accept you into that facility?
yes, in conjunction with my parole, which has been transferred to Dallas County.
Okay, and you are currently on parole, and have you been in contact with your parole office?
Since I've been incarcerated, yes, since they lifted the blue warrant, not so much. It's just been a matter of them allowing me to post bond or either wait on court. If I don't post bond and I just wait on court, then they have absolutely no interest in me until the legal matters settled
And if you were able to post bond, are you required to meet with your parole officer immediately?
immediately.
Okay, and do you know what's the name of your current parole officer?
It was Vicky Jackson. I have not been notified of my new parole officer's name. It's just been transferred to an office in Dallas County.
And ultimately, you understand that if you were able to post bond, if you didn't show up for court, this court would revoke your bond and likely double what it was set at.
Yes,
And can you assure the court that you will make all court appearances as scheduled?
yes, I can assure you of that.
And what family members have you been in contact with that have suggested to you that they could help you post a bond?
My son currently has his own roofing business, and he's the one that has suggested that he wanted, that I first filed for a bond reduction, and if I receive one, possibly, be on my Christmas.
So are you asking the court to grant you a personal bond on the unindicted case under 17-151?
Yeah, on that one, just by, just according to the law,
Right.
On the others, I'm pleading the mercy of the court.
And how much are you asking the court to reduce CR 22-126 to, from 500,000 to what?
I would, if you're honest, if you're asking me to be honest, I would ask the court for a personal recognizance on that bond.
And you understand that's not likely, but
I understand,
But it is-
I'm just being honest.
right. And you would have the same answer for CR 22-127.
Yes, sir.
Pass the witness.
State.
Mr. Collier, I apologize if you said this and I missed it, but what means of transportation do you have if you were to make bond in these cases?
1997 371 Chevrolet pickup, ma'am.
Okay, and do you own that pickup?
Ma'am, I don't. My son has just purchased that pickup and he's guaranteed me that that pickup will be used to get me back and forth to court.
Okay, and would that pickup be you, or would you be relying on someone else for a ride, or would that be given to you?
Probably on the days of court, it would be given to me. Other than the days of court, I would be escorted by my son to and from work and back and forth to the sober living men's facility until I purchase my own vehicle again.
Your Honor, I pass the witness.
Mr. Schmidt, anything further?
Nothing further, Judge.
Any argument, Mr. Schmidt?
Judge, no, we would ask that the court, take into consideration the testimony. I would argue that, 750,000 and, well, close to $1 million cumulative is excessive. In addition, I would argue that under 17-151, Mr. Collier is entitled to a PR bond on the unindicted case.
Thank you, Ms. Isel, any response or
Yes,
argument?
sure. Yes, Your Honor. As to the aggravated kidnapping that's unindicted, the state would agree that Mr. Collier is entitled to a bond reduction on that. We have no objection to a PR bond on that particular charge. However, we would ask the court not to reduce his bonds on the other two charges. There is a capital murder that is indicted, as well as an aggravated assault with a deadly weapon. We would ask there be no contact orders attached to any bond, current bond or reduced bond, on the aggravated assault charge, as there is a victim out there on that one. Judge, obviously, with the capital murder charge, the state has significant concerns about the interest of the community and the safety of the community. Should Mr. Collier be released? In addition, he is not being released somewhere in Van Zandt County, which also causes us cause for concern in terms of his ability to show back up. So for all of those reasons, we would ask that the court remain those two bonds. There already will be, with the PR of the aggravated kidnapping charge, that will be a significant reduction on the cumulative total. And we would ask the court to hold steady at that.
Thank you, Ms. Isel. All right, the court will take the testimony under advisement. We'll issue a ruling at the end of the docket, and we'll provide that the court's decision to counsel. And Mr. Collier's also set for pretrial today, Mr. Schmidt.
That's correct, Judge. I filed a motion to press. We'd asked it to be set on an evidentiary docket, and I'll get with Ms. Heisel to narrow down the issues prior to that date.
All right, remind me about your availability in January. My next evidentiary is January 26th. I remember you saying that you had some travel issues, I think.
I did, Judge. I will be in town on January 26th. I think my concern was piling up 20 or 30 cases. However, on Mr. Collier, it's a high intensity hands-on case, so I think I can be prepared to go forward on that date, and it gives me sufficient time to meet with Ms. Heisel prior to that. So I think we could do that date on.
So, yeah, so we have 126 or we have 223. I don't mind 223 if you need the time.
Well, let's do 223, Judge. That you set me up for that, but I'll it's possible. It's possible that me and Ms. Heisel will come up with some agreed.
Okay, I didn't mean to set you up. I just got more reasonable as you were talking.
I understand.
I'm ready, Mr. Schmidt.
We have a plea on Garrett Joslin.
All right, Mr. Joslin. This is CR 22-149, State versus Garrett Lee Joslin. Mr. Joslin, sir, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can lower your hand. All right, Mr. Joslin, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Sir.
Have you ever been diagnosed with a mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney?
Yes.
Do you feel like you've had enough time to speak with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Mr. Joslin to be competent?
I do, Judge.
And have you explained to him his rights as they pertain to this plea agreement?
Sir,
And you believe he understands them and the waivers of the rights he's making therein?
I do.
All right. Can you tell me what the terms of the plea agreement are?
Judge, upon a plea of guilty, the state's recommending punishment be assessed at 3 years TDCJ, $1,500 fine. In addition, they're going to take into consideration 1245 Texas Penal Code, DA 2022-1414, DA 2022-1413, 2022-1401, and then 2022-0504. The weapon will be forfeited per the judgment.
And is it a weapon used in this offense or one of the 1245 offense?
I believe it was this offense. This is the unlawful possession was seized.
All right, thank you. All right, 290 court costs.
Correct. 100 reimbursement fees.
You said 100.
Yes, sir.
And does Mr. Joslin have any credit time towards his sentence?
73 days.
All right, Mr. Joslin, you heard the plea agreement that Mr. Schmidt just read to the court.
Yes, sir.
That's what you understand the plea agreement to being what you're asking the court to approve.
Yes, sir.
All right, the court finds that you're indicted with a third-degree felony offense of unlawful possession of a firearm by a felon. Third-degree felony in the state of Texas carries a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and an optional fine not to exceed $10,000. The court, if it approves this plea agreement, finds that it legally fits within the range of punishment. Mr. Joslin, how do you plead to unlawful possession of firearm by felon?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Mr. Joslin, has anyone threatened, forced, or pressured you to make you plead guilty today?
No, sir.
All right, the court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to state's evidence?
No objection to state's evidence.
State's evidence, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
Yes, Judge. Basically, by entering this plea today, I was on the phone with Ms. Heisel. It is our understanding by accepting the plea that all of Mr. Joslin's Van Zandt County business now pending as being resolved. We went through the various offenses. I think that Ms. Heisel and I are in agreement that this should resolve everything. We don't expect anything else that's hanging. This office is aware of, but I just wanted to make the court aware of that. In addition, I think that the judgment, the state had indicted with an enhancement. The judgment does not reflect that. I presume it's not been made on the record, but they intend to abandon the enhancement paragraph in order to wrap up this case. And I'd let the state speak for themselves on that.
Judge, I'm not sure if this is Ms. Heisel's or mine. That is I believe that is our agreement. That was our agreement previously. Theoretically, the plea offer as enunciated by the defense would fall into either punishment range. I don't believe that it changes anything. So state would abandon it this time and proceed under the 3rd-degree felony punishment range.
All right.
And Judge, as to the other records, Mr. Schmidt has made me aware that Mr. Joslin was apparently booked in on some additional charges other than what was listed in the face of the judgment. The state has 1245 everything we've received in our office, everything we have a DA number for. It's hard for us to send a disposition on something that we have never received, but it is the state's intention to wrap up all of Mr. Joslin's business with this plea.
Thank you, Ms. Heisel. All right, state, can you give me the facts to support the plea?
In this case, Grand Saline Police Department sees the defendant driving a vehicle with an expired registration and sees him fail to stop at a stoplight and pull into a Sonic. The stoplight, the Sonic is at the stoplight. He makes a left. He makes a turn without stopping into the business. Grand Saline recognizes defendant and knows that he has municipal warrants from Grand Saline Municipal Court. They arrest him on the warrants and they are going to search incident to arrest. He admits to marijuana in the vehicle. In the natural void behind the glove box is marijuana and a nickel-plated Raven Arms .25 caliber pistol, which is the seized weapon that's being forfeited to the arresting agency in this cause, Judge.
Thank you, Mr. Any objections, Mr. Schmidt?
No, Judge.
All right, then based on the evidence presented to the court finds that there is enough evidence to convict Mr. Joslin. The court will follow the plea agreement in this case. Hereby convicts Garrett Lee Joslin of unlawful possession of firearm by a felon, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,500 fine, $290 court cost, $100 reimbursement fees. Court dismisses under section 1245 DA 2022-0504, 1401, 1414, and 1413. And the court orders the weapon seized in this offense, the .25 caliber pistol, to be forfeited. And the court will award Mr. Joslin 73 days credit towards this sentence for the time that he has already spent in jail. Mr. Joslin, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Step over with the deputy to be fingerprinted. Who's next?
Cody White.
CR 21-346, State versus Cody D. White. Motion to revoke. Go ahead, Mr. Smith.
Judge, we're going to ask for another reset on Mr. White. Mr. White is a trustee here at the jail. I've come over a couple times to grab him on my normal visits, and he's out working for the county. I need to meet with him before we move forward. If the court wants to set it on a contested docket, that usually motivates me and the rest of us to hopefully resolve this case.
All right, court sets Mr. White for contested hearing on January 26th. That'll be at 1:30. Mr. Schmidt, let's go ahead and call Mr. Warren Pruitt. We can just call that for record purposes, okay? CR 2245 State versus Warren Clay Pruitt was set for arraignment today. Court has reviewed Mr. Schmidt's motion for competency evaluation. The court has approved that. And so the court has ordered him to undergo forensic evaluation. So the court will set this for status on the competency report. and we'll set this on February 7th. Hopefully we'll have more information within 30 days of the order, but we'll go ahead and set it for February 7th.
Thanks, Judge.
Go ahead, bring up your next client. Sorry about that. And who is this, Mr. Schmidt?
This is Edward Drummond.
All right, this is Edward Joseph Drummond, CR 22373 for arraignment. Go ahead, Mr. Schmidt.
Received a copy of the indictment, his name spelled correctly. Understands what he's charged with. We waive formal reading. Enter plead not guilty, ask for pre-trial.
All right, the court will find that Mr. Drummond has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record. Court will set this matter for pretrial hearing on February 7th at 1:30. If Mr. Drummond, if you make bail in your case, then your hearings will be at 9 a.m. on the same day. Okay?
Sir.
Who's this, Mr. Schmidt?
You call me.
Matthew, is it Mayovan? Mayovan? Is that how you say that? Your middle name? Mayovan? Coleman, CR 22268, set for pretrial. Go ahead, Mr. Schmidt.
Judge, we don't have any contested motions at this point. Ask that it be set for docket call.
All right, court will set Mr. Coleman for docket call on February 7th at 1:30.
Judge, everybody that's currently in here has been attended to. I would say that we have Robert Gerard left. Obviously, the court's aware. Filed a motion for competency on Mr. Gerard as well as a motion to withdraw. He and just for the record's sake, I did meet with Dr. Ingram yesterday morning. He was over here doing a second interview with Mr. Gerard. So I believe he's on the list to be brought in. I just want to give you a heads up before we start that.
Okay, and so is the announcement going to be that we just need to reset and wait for the second report of Dr. Ingram?
Yes, sir.
And is Mr. Gerard going to want to take up the motion to withdraw?
I haven't spoken with him since I filed the motion, Judge. I have been in contact multiple times with Dr. Ingram since I filed those motions, and I believe from the doctor that it's Mr. Gerard's understanding that I'm not his lawyer anymore, even though I made the doctor aware of the status. So I'm not sure what's going on right then, but I expect to talk to the doctor probably tomorrow with an update on his final interview with him. He did give him several complex tests that I expect results on pretty quickly. But either way, if you want to bring him in, that's fine. I don't know what his mental status is today.
I don't see a need since we are, since court has granted your motion on the competency, I don't see the need to bring him in. Court wouldn't be taking up the motion to withdraw until we get some kind of report from Dr. Ingram. So unless, as long as an officer of the court, you can assure me that there's no other physical issues or anything that need to be brought up on Mr. Gerard's behalf, then I'm fine with just rescheduling it for a status on his competency.
Yes, Judge. And like I said, I've been in contact with all the parties that be. Everything that I know, the court is aware of. And like I said, I met with the doctor yesterday morning. I expect to report pretty quickly. Yeah.
Okay, so we'll reset Robert Gerard then for docket call and status on competency Evaluation, we'll set that February 7th. At 1:30. And while we're talking about that, about competency restoration, for the record, cause number CR 21-126, 127, and 2021-90, State versus John David Horton. I have a note that Mr. Horton was transferred to Montgomery County for restoration on October 26th. That's probably our last, that was post our last hearing, I believe. So we'll just put, we'll reschedule this for an update, say in March. I've got March 7th and March, how about March 28th? That's a Tuesday. You foresee having any scheduling issues on March 28th?
No, I think I'll have submitted something for the spring break for my kiddos, but I don't think that falls on that.
No, that would be 2 weeks after that.
Yeah, that should be fine, sir.
Okay, all right, so we'll just put Mr. Horton in for just a status on his restoration, see if we can get an update from the facility.
Thank you.
That March 28th.
And I think having taken care of those three individuals, I believe that's all we have, or all I have. On your docket this afternoon.
Yes, sir, I believe that you are correct.
Thank you.
Thank you for your work today, Mr. Schmidt. I do appreciate you. Let's see, CR 2156, State versus Robert Cecil Crane Jr. I don't see Mr. Noel.
I don't have him on my docket.
Well, you don't have Mr. Crane because he was transferred to TDC, is what my notes say on 11/18. Let me look in on their website, make sure he's there. State, have you had any conversations with Mr. Knoll regarding Mr. Crane at all?
No, Judge, I've reached out to Mr. Knoll by email and I've not heard any response back from him on what we were going to do with Mr. Crane.
All right, I should. Crane is appearing in the Beto unit. Maybe it's Beto. I don't know. Maybe it's Beto. You said you work there? It's Beto? Maybe Beto. Yes, it says that he is there. Pro eligibility date 9/6 of next year, September 6th, projected release date March 7th, 2031. Looks like he went down from Wood County on 2 10-year sentences on 9/1 of this year. So 9/1, he got his sentence date and has been down in Wood County and I guess transferred to TDC. So I
And
guess.
Your Honor, just for the court's information, I emailed Mr. Knoll an updated offer based on that plea in October 11th. And then followed up with him last Friday, the 9th, and have not received a response to either one of those.
Mr. Abraham, do you have any updates from Mr. Knoll as to Mr. Crane or why he's not here today? No. Okay, state's gonna be asking for writ of attachment for Mr. Knoll, is that right?
Correct, Your Honor.
Correct, okay. All right, so let's set Mr. Crane then for status. We'll set him February 7th. We'll put status custody / plea. I'm going to infuse some positive thinking here. Custody / plea / question mark. And then I'll leave that question mark. Y'all can put whatever y'all want to put in there, y'all can.
All right, I believe that will conclude this afternoon docket. Unless the state's aware of something that I'm not.
That's all we've got, Judge.
That
All right.
appears to be it.
All right, appreciate y'all's work today, and we'll be